Okay, in this video lecture, we're going to be talking about the last of the substantive requirements for patentability, namely non-obviousness. So in previous classes, we've discussed patentable subject matter, right? What kinds of inventions or discoveries are the kind of things that can be protected by patents? The utility requirement, the requirement that in order to patent a invention or discovery, you have to show that it has some kind of use. You can't just patent the thing itself. You have to patent it in the context of a particular use that you're putting it to. Novelty, in other words, it can't already be known. And then non-obviousness, which on some level you might characterize as being, not only does the invention or discovery have to be novel, it has to be non-trivial novel, right? In other words, the novelty can't be merely a formal novelty. It has to be real novelty in the sense that it wouldn't be obvious to anyone working in the art that this way of solving a problem would be an appropriate way of solving it, with, I think, kind of the implication that maybe if it's obvious to do it, then people are already doing it, just not necessarily applying for patents for it or disclosing it in a way that would be known, or that they would think of it themselves as soon as the problem presented itself to them. They don't like, we don't want people to anticipate problems that just haven't quite arisen yet, but the solution to the problem is obvious. Okay, so non-obviousness is provided for in section 103 of the Patent Act, which basically just says you can't get a patent over things that would be obvious to a person having ordinary skill in the art. So what does that mean in practice? Well, it's really meant a lot of different things in practice over the years. The courts, the Supreme Court, and now the Federal Circuit have been back and forth over the meaning of the non-obviousness requirement for a really long time. One of the early sort of invocations of non-obviousness was back in 1850, Hotchkiss v. Greenwood, relating to a patent claim over a method of creating knobs or fixing knobs to shafts. Essentially what the patent did was say, well, people attach knobs to shafts, in lots of different ways. One way that it's done in previous patents is a clay knob to a shaft with a rod. Another way is with a wood knob to a dovetailed shaft, and we want to combine those two different ways of attaching knobs together. So dovetailed rod and clay knob, and the court said, that's already out there. Anyone could think of using the same method of attaching a knob to a shaft. It's obvious and therefore not the kind of thing that patents should be protecting. Similarly, in Reckendorfer v. Faber, there was a patent claim over combining a pencil with both a graphite, a lead, and an eraser. And the court said putting pencils and erasers together, that's two great tastes to go great together. We're not going to let you patent that. That's just too obvious to do. Likewise, there were a number of other patents over the years where the court considered the question of obviousness until the mid 20th century, when the bar for non-obviousness had risen quite high. Right. So the Supreme Court was essentially adopting this position that, you had to kind of, in a sense, prove that your invention or discovery wasn't obvious by showing that it embodied some kind of flash of genius, right? That there was something really special about it. And a lot of people thought that was too stringent of a standard, right? That patents, they can't just be trivially novel, but they don't necessarily have to reflect absolute unanticipatable genius. And there's also kind of a concern that, maybe the court was being a little too strict, right? I mean, a lot of things look obvious once somebody's invented them, but if they hadn't done it before, then was it really obvious in the first place? Or maybe they just saw something other people couldn't see until they showed it to them. So then the Supreme Court started kind of pulling back on the stringency of the non-obviousness requirement in order to make it a little bit easier to get patents. And the Federal Circuit kind of ran with that, right? And eventually the Federal Circuit adopted for itself what became known as the teaching suggestion motivation test, which essentially said, look, unless the prior art is essentially telling you to do this thing, then the combination of prior art elements into a new patent claim is going to be non-obvious. In other words, there's kind of teleological quality to it, right? It has to be kind of like the prior art elements so strongly suggest doing things in the way described in the patent that no FOSITA would consider doing them otherwise. Kind of the Supreme Court and the Federal Circuit together kind of came up with a set of kind of principles lying behind the non-obviousness analysis, right? So from what perspective do we ask about non-obviousness? Well, it's not from the perspective of a reasonable person. It's from the perspective of a person having ordinary skill in the art. In other words, we ask, would a person who's working in this field find the patent claim in question to be obvious? Not would the average Joe find it obvious. Second, as I mentioned earlier, it's what we call a negative requirement, in the sense that we deny patent protection to patent claims that are obvious, but we don't have a positive requirement associated with it. We don't say it has to be reflective of some kind of genius. It just has to not be obvious. Right. We try to avoid hindsight bias, right, by saying, we're going to put ourselves in the position of someone looking forward to see if you would anticipate this invention, not looking backward to say, well, now once it exists, do we think it was obvious? There's also a limitation on what prior art is relevant, right? So only prior art in the same field as the invention or discovery in question is relevant to the obviousness analysis. We'll talk about that more, that requirement more in a minute. And in addition, kind of feeding back into the negative requirement quality, it's an objective test, not a subjective one. So we want to say, from an objective perspective, would this be non-obvious to a FOSITA working in this in the same field as the patent application? Okay. So the Federal Circuit, as it's so want to do, gradually sort of narrowed the non-obviousness test into increasing irrelevance by finding that most inventions or discoveries were not obvious, and kind of leaning hard on this teaching suggestion motivation test. And then the Supreme Court returned to the question in 2007 in the KSR v. Teleflex case. Okay, so what happened there? Teleflex and KSR are both in the business of making automobile pedals, and Teleflex has a patent over a automobile pedal design that combines an adjustable pedal and an electronic sensor. It is called the adjustable pedal assembly with electronic throttle control. So both adjustable pedal assemblies and electronic throttle control are known in the field of automobile pedal manufacturing, but they hadn't been previously combined together. So there's prior art patents reading on both elements of this patent claim, but no previous prior art had combined those elements into one patent. So we can see how the novelty requirement is satisfied, right? We've got prior art reading partially onto the claim, but not reading onto all the elements, right? So it's still novel if the prior art doesn't read onto all the elements of the claim. The question then becomes, even though it's novel, is it only trivially novel, right? Is it perhaps an obvious solution? So the, on prosecution, the PTO initially found the patent claims to be obvious, but ultimately relented on Teleflex's insistence that its patent claim incorporated small changes from prior art patents. But the district court granted summary judgment to KSR when Teleflex sued for patent infringement, finding that the patent claim was invalid because it was obvious, right? So then when the the district court decision went on appeal to the Federal Circuit. The Federal Circuit applied the teaching, suggestion, and motivation test that it had developed and found that the patent claims were not obvious because they weren't entailed, as it were, by the previous prior art. Patents, it combined those elements, but the Federal Circuit said that these prior patents didn't tell inventors that you should combine them in this way. So the Supreme Court took the Federal Circuit decision up on cert and ultimately reversed the Federal Circuit, saying in essence, Federal Circuit, you're just being too patent owner friendly on this one. The TSM test that you've adopted is just too rigid, right? It goes too far. It's too friendly to patent owners, and it's not holistic enough. You're not considering the context in which the invention or discovery has been generated. Broadly speaking, it seems like the Supreme Court is kind of suggesting that merely combining two well-known elements from a field into one when somebody hadn't previously done it before is probably not enough, or at least not necessarily going to be enough for non-obviousness. And again, right, I mean, it might very well be novel. The question is whether it's trivially novel, and the Supreme Court's decision in KSR seems to suggest that it can be if Fozita's working in the field would be inclined to solve problems by making this same combination, right? In other words, so the implication in KSR is like, look, this was a problem everyone was working on. This is an obvious way to solve the problem in certain circumstances. And we don't want people to sort of preemptively go out and just patent every possible combination of prior art elements in the hope that they get the one that's most attractive, right? The solutions have to be real solutions. They have to be non-obvious solutions. They have to be things that people wouldn't automatically think of on their own under the circumstances. So essentially what the Supreme Court says is, in order to determine whether or not an invention or discovery is obvious, you have to look at the context in which it came to pass and ask, was this a known problem? And is the solution proposed an obvious solution to a known problem? And the Supreme Court thought in KSR that yes, this was an obvious solution to a known problem. So there's a kind of a big picture, holistic question here, right? Should courts be sort of lenient or strict about the non-obviousness requirement, right? And this gets back to the question we had earlier in the class, kind of about intellectual property writ large, right? You know, what are the error costs in either direction, right? I mean, if courts are finding a lot of inventions obvious and being real strict on the non-obviousness requirement, well, it means that it's going to be a lot harder for people to get patents. And there's a risk that courts maybe will deny patent protection when people ought to be entitled to patent protection. But, if we go the other way and get too lenient, then we're going to be handing out patents willy-nilly, and people will be getting patents issued to them when they don't really deserve it, right? So the question is, what direction do we want to make errors, right? Or really kind of from policy perspective, what do we want to expect? What do we think the patent system should expect from patent applicants in order to kind of justify or legitimate granting them a patent in the first place? Okay, so there's also a presumption of validity, right, which comes up in the context of invalidation of patents on review, right? The idea is that once the patent office has reviewed and deliberated over the granting a patent in the first place, there's a presumption that as the agency tasked with doing this, that it did it correctly and that the patent issued is in fact valid. So we kind of already have a thumb on the scale for patent owners. The question is, how should we think about that and the consequences of that in applying the non-obviousness test? Okay. Well, after KSR, the Federal Circuit then had to rejigger its own standards for determining non-obviousness. And it did so in the St. Jude medical v. access closure case. So St. Jude had several different patents on methods and devices for sealing vascular punctures or needles, essentially, in people's skins. Essentially, the existing problem was that, you give people a shot, and then when you take the needle out, the people bleed, and you would have to hold something on the skin in order to wait for it to clot. It's time-consuming, painful, blah, blah, blah. So, can we come up with there's got to be a better way, right? How can we make it so that this will work better? And basically the idea is, well, rather than wait for the blood to clot, why not, put a plug in there so that it just closes up the hole, and that'll promote healing, et cetera, et cetera. So St. Jude looks to previous inventions in the field and develops its own method of essentially asserting a plug that presses up against a balloon inserted along with the needle, the various parts working together in order to facilitate proper positioning of the plug in question, and brings an action ultimately against access closure for violating this patent. The defense from access closure is that, no, this is obvious, right? Other people have already been making other solutions in this same area. Look to KSR, right? The court said just combining two things isn't enough for patentability. Well, everything you've suggested is present in prior art patents. Therefore, what you're claiming is obvious. And the district court agreed, right? Finding that the district court found the district court rejected the defense from access closure, right? Saying that no, this was not in fact obvious. And the Federal Circuit affirmed, right? And why did it do that? Well, it said, look, it's true that previous patents, prior art, taught each of the elements that are included in this patent independently. The thing is, it didn't teach this solution, right? So they combined these different elements in a novel way. And what was not obvious was using these particular elements in this particular way. And even though all of the elements pre-existed this St. Jude patent, because St. Jude combined them in a non-obvious way, that non-obviousness is sufficient. Okay, so one big kind of difference between the novelty requirement and the non-obviousness requirement, which are obviously closely related to each other because they kind of get at the same question, is what prior art is relevant when you're doing the analysis, right? So when we do a novelty analysis, any prior art from any field is relevant. In other words, if what's being claimed in the patent is known at all to anyone anywhere, then it's not novel, right? So novelty is kind of an existential question, as it were. We just look to the entire universe of knowledge and say, is that knowledge anywhere? If the answer is yes, then it's non-novel. Okay, for non-obviousness, it's a wider scope, right? So the non-obvious, the non-obviousness requirement kind of provides for the invalidation or the refusal to grant a much wider range of patents for a much wider range of reasons, but the scope of what counts for the purpose of the analysis is narrower, right? So for the non-obviousness analysis, we don't look just anywhere, right? We only look to prior art within the field in which the patent claim is actually being made, right? So we don't look outside the field, right? Because the idea is it's non-obviousness to look to other fields and bring in innovations from other fields into a new one, right? In other words, looking outside your own field is sort of prima facie evidence of non-obviousness. Okay, and how does that work? Well, it's kind of illustrated in the In re Clay case. So Clay is appealing the rejection of his patent claims as obvious. So basically, he went through patent prosecution. The patent office refused to grant him a patent because it thought that what he was claiming was obvious. And so he's now appealed that rejection administratively all the way up to the Federal Circuit. What's the nature of the patent? Well, it's over a method, essentially a method of storing fuel in a tank that isn't quite full, right? So basically, you don't want to store tank in store fuel in a tank that has air in it. The air is bad for the fuel, I guess. So what do you do about that? He proposes inserting gel into the empty space that will take up the air and prevent oxygen from contacting the fuel. So there's prior art in the field that teaches a method of using basically a giant balloon to fill up the air in a not quite full tank in order to store fuel. And in addition, there's prior art relating to using gel in the process of fuel storage and extraction in kind of underground reservoirs of fuel. And Clay takes these two different technologies and puts them together, saying, it's kind of like a balloon, but put the gel into the tank rather than a balloon. Patent office says that's obvious. Presumably it's saying, look, the field in question is petrochemical engineering. These are both from petrochemical engineering. Therefore, putting them together is obvious, and we're not going to grant the patent. And the Federal Circuit reverses, right? It says it's non-obvious because the context in which the gel in particular was being used was a very different one from this context, right? So it was being used underground rather than a tank, and it was primarily being used for different purposes, right? It was about kind of guiding the fuel or guiding the oil in the way you want it to go, rather than storing it in the tank, right? So repurposing this technology that had been developed for one thing, using it in a different context, that was not obvious. Therefore, it is patent.